The next item, item C on the agenda, is to review and discuss the rental registration program. I know that Mr. Magner is going to have his presentation, and I'm sure that Mr. Johnson will have some comments, but I also wanted to just set the stage just a little bit. This is a topic that is going to be about an ordinance, and from my perspective, these ordinances get set, and the merit or the details of them get worked out as we implement them. And so I know that in your one-on-one meetings with the city manager, each of us has had conversations with the manager about perhaps relooking at this, fine-tuning it, asking, now that we've got this ordinance, how is it actually played out? And so based on all of our requests for that review, we are bringing it tonight. So with that, I will turn it over to Mr. Johnson.
Thank you, Mayor, members of the council. The mayor just stated certainly the feature of rental registration has been in place since about '03, but particularly in '11, I think some additional features of that came into place, and so now it's been about 2 years. And as the mayor said, really wanted to again revisit that. Certainly, there's been community commentary over the last while, but also on top of that, I think we've had a lot of programmatic review as well. And with all that, I've asked Don to continue to review all this consideration and see if there are refinements that are appropriate for us to now do into this program. Absolutely, though, trying to maintain and achieve the objectives that were so well appreciated by trying to establish this program, and finding that balance that certainly we need to have between property activities, but also the community at large, as all properties sit within neighborhoods and within a community. And so with that, let me ask Don to take us through that. Don has a few, now with a couple of years going here, we have a couple of years of statistics, I think a few facts and insights that I think let us do these refinement suggestions tonight. And at the end of that, certainly as we confirm these refinements, if that's to your satisfaction, certainly an amendment to that ordinance would be made to make that our go-forward consideration as immediate as you're ready to make that action. So Don, appreciate the work you've done on this and continue to track this process, and if you kind of guide us through some of the refinement conversations we've been discussing.
You bet. Thank you very much, Mayor and City Council. Appreciate the opportunity to come before you tonight. As you know, for many years now, we've on a very regular basis looked at our current policies and programs and ordinances, and at least twice a year or so come back to you with suggestions for refinements that are not only based on the application of the code in the field, but also the feedback that we get both from our enforcement officials as well as our property owners and residents. And that's really what tonight's all about. What we'd like to do to begin is to review and kind of discuss some of the elements of the current program. In particular, I've broken this out into kind of three facets. One is the registration requirements. Two would be the inspection process, and then three would be the fees. Also like to share with you some opportunities for enhancements that we see. We've got a couple of different strategies to share with you, and the main goal for these are to really kind of twofold. One is to improve consistency with some of our other programs. As you well know, we've had a multifamily inspection program operating here in the city since the mid-1990s. And this is a situation where we go in on an annual basis to all of our multifamily, all 60-plus multifamily residential properties, and we do an exterior inspection as well as interior inspections under a variety of circumstances. So looking for opportunities to make this more consistent. Also to render the requirements for this program easier for residents and property owners to understand, and then and most importantly to comply with. And then finally we'll discuss some next steps and provide you some options for how to proceed. As Dan mentioned, the program dates back to October 2003. At that time, City Council identified a rental registration program to be necessary, as I mentioned, to be consistent with other things that we were doing in the city to protect neighborhood vitality at that time. The purpose of the program is to protect both vitality of the properties themselves as well as the adjacent properties, the block and the neighborhood, to protect that integrity by ensuring that the rental properties are maintained in a safe and healthy manner, and that the tenants are providing dwelling units that are in compliance with minimum, and minimum is a key word there, minimum fire, building, and health standards. As I mentioned, if you look on our website, you will see this statement in three different places. It's with our residential neighborhoods and the code enforcement program that we apply to them, our multifamily properties, as I mentioned, and to rental properties. So what we're doing in this regard is very consistent with a multifaceted approach to trying to protect our city, our community, and our neighborhoods and make sure that residents, whether you own a property or whether you rent a property, have a safe, healthy, desirable place to live. And that truly is the goal. Owners of rental units under the 2003 ordinance were required to begin registering their property on an annual basis with the city, and that's if the whole building was used as a rental or if part of the building was used as a rental, even one room, for instance, which we do have those circumstances. You might ask, how do you identify rental properties to ensure that the registration requirement is being met? We do that in a variety of ways. First, of course, we cross-reference our ownership records with our utility records. Our field inspectors, code enforcement officers, building inspectors, police, really everyone who works for the city are on the lookout and report those as they go through their normal course of business. If they run into a rental property and it's not registered, they'll not only take the opportunity to educate the tenant or the property owner as to with respect to what's required, but they'll turn those into us. We search online listings, review newspaper and other publications for listings. Tenant complaints are a big one. We have an opportunity here to provide a really valuable service to tenants, particularly tenants who are new to living in single-family homes. So very often a tenant will bring a property to our attention by way of asking for clarification or assistance or an inspection. And then finally, citizen complaints. Residents, and this is last for a good reason. This is probably our number one most effective way. It's homeowners that live in our neighborhoods, that understand what's happening on their block, understand what's happening in their neighborhood, and understand the requirements that the city has set forth. They share that information with us on almost a daily basis. And as you recall, as part of the November 2011 enhancements, we created an online tracking system. And this is something that provides a resident an opportunity, a homeowner an opportunity to go online to see if a property that is being used as a rental unit in their neighborhood is listed. If not, they can help the city by bringing that to our attention. It also helps prospective or tenants looking for rental properties have an opportunity to kind of see what's available. I think one of the most unintended consequences that we really didn't foresee in the way that this is utilized, it's utilized by our neighborhood associations, particularly our voluntary neighborhood associations, who want to reach out and make tenants feel like they're part of the community. The number one reason neighborhood associations go online to download this information is to customize letters and mailers and flyers and things of that nature to try to get tenants to become part of the neighborhood and try to get them to get involved. So it's a really neat use that neighborhood associations have kind of developed, as well as a very effective tracking tool for us. As I mentioned, November 2011, via Ordinance 3847, a number of enhancements were made to the program. First, the annual registration fee was increased to $75. I've talked about some of these other enhancements, and the idea there was to help recuperate the cost associated with administering this program. It's a very specific tie-off to what was going to be offered in terms of benefits to homeowners and residents, and the cost associated with doing that. An evaluation criteria was updated and a score sheet was adopted to assess the conditions of the property. The idea here was not to show up and surprise a homeowner or a tenant. We wanted to put out there online constantly and put out there for every homeowner and tenant exactly what we were going to be looking at. We didn't want any surprises, so we developed a score sheet and said these are the standards by which you will be evaluated. There's no surprises when it comes to the inspections. A score of 85 or higher was required to pass the annual inspection, and any home that scored less than that, any property or dwelling that scored less than that, was subject to a re-inspection. And then finally, an inspection was required upon a change of occupancy. So essentially, before you move your first tenant in, or within 30 days, you have to have an inspection, and then all subsequent inspections within 30 days of a new tenant moving in, you're supposed to request that inspection. So let's start off talking a little bit about registration considerations. As I mentioned, we're going to look at registration requirements, inspection process, and then fees. So as I mentioned, upon converting a single-family residential dwelling to a rental unit, the owner is required to register the property. That's a $75 fee. And if that's any time generally between January and October, that fee is assessed for the current year. If it's subsequent to that, and it gets closer and closer and closer to January when we would send the renewal, that fee is kind of waived until we get to that January period. So it's very, very pro-homeowner, very friendly towards, I think a friendly approach towards the homeowner so that they're not paying a fee in November and then asked to pay another fee in January. Registration of the rental unit must be renewed annually. Subsequent to that, again, in January, there's a $75 invoice that's mailed to all property owners, as well as a registration form that can be updated if there's been a change of occupancy, or any other information that may have changed about the occupants can be updated at that time. Failure to renew the registration is a criminal violation, as is failure to pay the registration fee. What I've done here is summarized, and all of the data that we'll look at will be from January 2012, which is when really the new requirements took effect. They were passed in November of 2011, but they became effective in January 12 until present day. So if you look at the 2,700 or so rental properties that we currently have registered with the city, since that time period, we've sent out 460 notices to property owners who have failed to register. So predominantly, this is a new rental property that goes on the market. Most times the owner just doesn't understand what's expected, so we take that opportunity, educate them, they turn in the registration, pay their fee, and they're good into the system until the next year. 538 times we've had to remind somebody that their registration is past due. So this would be somebody who registered in 1 year. The subsequent year, an invoice was sent to them with a registration form to update, and for whatever reason they failed to turn that in. And then about 500 times or so we've had to identify and notify folks who have failed to pay the fee. You'll see that pretty high level of compliance in terms of voluntary once that initial notice is sent, from the time where we actually notify them to the time where we actually have to take some kind of legal action, issuing a citation. So a very high level of voluntary compliance overall. But you'll see about 170 times or so over the last 19 months we've had to cite someone for not doing one of those things. And then usually high rate of success in court in terms of resolving those. In terms of inspections in our current inspection property, the ordinance states that a property owner must schedule inspection within 30 days of making that rental unit or offering that rental unit for rent for the first time, or within 30 days of all subsequent changes. A tenant must make the home available for an inspection. If the tenant refuses to do that and doesn't consent to an inspection, an administrative search warrant can be sought from the city's municipal court, and that inspection can be conducted under the purview of that warrant. Let me talk a little bit about warrants before we go forward in the inspection process. The city's ability to to seek a warrant from a magistrate is actually authorized under the Texas Code of Criminal Procedures, which states a search warrant may be issued for the purpose of allowing an inspection on any premise to determine the presence of a fire or health hazard, an unsafe building condition, or any violation of a fire, health, building regulation, statute, and ordinance. So how do we go about achieving that? So if an enforcement official feels that there is a situation that warrants conducting an inspection via warrant, if a tenant does not consent, he or she can, if they feel that they have that probable cause to believe that there does exist a violation of the Code of Ordinances, we can request from a magistrate a warrant. What we have to do, our burden of proof is to show that there's probable cause for that warrant. Now, this is a pretty widely accepted definition here of what probable cause is. This is extremely important to our process and what we demonstrate before a magistrate when we try to do this. So probable cause is defined as a reasonable amount of suspicion supported by circumstances sufficiently strong to justify a prudent and cautious person's belief that certain facts are probably true. That's a really widely accepted definition of probable cause. It doesn't mean for an administrative search warrant. It doesn't mean just for code enforcement. That's for any standard. When you go before a magistrate, that's what you're trying to demonstrate. As I mentioned, an administrative search warrant must be reviewed and approved by a magistrate, and it's the magistrate that determines if we've met our obligation to show and to demonstrate that there is that probable cause. Once we turn that in, we have no interaction in terms of the review process. So what does that judge look for? Well, there are a couple of things. One is specified knowledge of someone creating and taking part in that affidavit. So that could be a public official, or it could be a next-door neighbor who has seen some activity over and over and over again, and we've utilized that person's affidavit in conjunction with our observations to obtain that warrant. Age and general condition of the premises. So that could be something that is extremely old, for instance. and that there was a certain type of wiring, perhaps, that was used in the buildings of that age. Reason to believe that that wiring, which could or could not be a potential hazard, is installed in that home. So that's how the age could come into play. Previous violations or hazards that were found. So if we've been in a situation before where we found, for instance, hazardous materials being stored in a residential district, that may be, in conjunction with other things, enough to obtain a warrant to go onto the property and confirm whether that condition is present again. The type of premise. So if there is if there's a use that could be potentially occurring that is very different than the premise would provide for, that could be enough. Again, the purpose for which the premises are used. And then finally, the presence of hazards or violations on adjacent properties. So if there is a situation where you have two homes and two properties and they're relatively similar in a lot of ways, and one has something that's illegal taking place, under certain circumstances, that could be enough. So it's not just what's going on in that property, it's what's going on properties in the immediate adjacent area as well. And these are the kind of things that all magistrates look for on all warrant requests, regardless of the specific topic at hand. So let me give you a couple of examples as it relates to what we do in code enforcement. So for instance, if there was a potential violation was an illegal business being run in the home, what would we have to demonstrate to a judge to obtain a administrative search warrant? One could be that we have, through our own observations, documented that customers are coming to the property on a daily basis. We've seen over and over that supply trucks are arriving at the property and unloading on a regular basis. Maybe we find a home address is being used in advertising materials for the business. And then, of course, as I mentioned, we could have verified complaints that would be in the form of an affidavit that would be used in conjunction with our material that would request that warrant be issued. Another example, too many people living in a home, for instance, which is something that's extremely important when you look at occupancy standards, particularly in single-family residential neighborhoods. So an excessive number of cars that are parked on a home on a given basis. And I'll take that example one step further. As we run the plates on those cars, they all come back to someone different. And that number of cars and those people do not correspond to what the registration, the rental registration states should be occurring there. An excessive amount of trash, for instance, if you've got trash that you would equate with perhaps 12 people living in a home and they're only supposed to be 4 non-related, that's enough to potentially enough to demonstrate that. And again, verified complaints from neighbors. What about the buildings themselves? A dangerous building or a substandard building? It could just be something as simple as seeing holes in the roof and what that allowing the weather to enter that building might do. It could be broken windows. It could be cracks in the foundation or the brick veneer or other structural elements to that building. So these are just the kinds of things. And what we're doing is we're saying reasonable people, based on these facts, would agree that there likely could be some additional things going on that would violate the city's code. That's a very reasonable, very basic way of looking at what we do when we try to obtain the warrants. Talk a little bit about what we found via this program. So since January of 2012, we've conducted 1,022 inspections in conjunction with the rental registration program. So that means 1,022 times someone has rented their home for the first time and we've gone out and conducted an inspection, or there's been a change in occupancy. 69% of the time we find at least one violation or more. So 7 out of 10 times we go out, there's something that we address. If you break those down and you look at what those come out to be in terms of the types of violations, about 52% of the time it's an exterior violation. About 48% of the time, it's an interior violation. So an exterior violation would be something like maybe overgrown vegetation, peeling paint. An interior violation might be something like a leaking faucet, a running leaking toilet, or a smoke alarm that doesn't have a battery, or the absence of smoke alarms entirely could be an interior violation. If you take that one step further and you look at life safety versus non-life safety violations, there's a little bit more of a distinction there. So our non-life safety violations are about 63%, and this includes both interior and exterior. So there's about 63%, and our life safety are about 37%. So of those 950 or so life safety violations, almost a third of those are smoke detectors, to kind of give you some perspective on what that is. We consider life safety missing blanks in a electrical panel, missing covers on sockets. We've been in situations before in closets, and and this isn't permitted by building code anymore, but once upon a time you could have an electrical panel in a closet. If that closet happens to be in a child's room and it's not locked and they're missing panels, that's a life safety violation. There's no doubt about it. So that's the kind of things that we're finding about a third of the time. Another good indication, I think, as we look at our code enforcement programs is what residents are seeing. I mean, we can be in neighborhoods, and we are in neighborhoods an awful lot as code enforcement, particularly when you look at the 3 different kind of programs we have, but we'll never get the sense, and we'll never have the sense that a next-door neighbor has about what's taking place next door to them or on their block. So we use the citizen complaints as a real gauge for what's taking place in the neighborhood. And if you look at, since January 2012, and you look at all of those rental properties that we have had registered, we've had about 750 complaints filed, and these are residents who are reporting potential violations. Sometimes we go out and there's one violation. Sometimes we go out and there are numerous violations that result from that complaint. But 750 different times a resident's called up and filed a complaint about a rental property. What you see here is the result of those investigations. So about 92% of the time when we go out, it's an exterior violation that we see. That 8% generally represents a tenant calling in and asking us to come out and look at something on their behalf. And when you think about that, there's only a couple of situations where that's not true. Too many people living in a home, for instance. You can get a sense of that from the outside. Activities that are taking place on the outside. So I can be a neighbor and call and complain that, and that's actually logged as an interior violation. Same with the business in the home, for instance. It could be I see a water heater on the curb, and I'm a neighbor, and there's no permit on file, which you can find by just going online, and I might call that in. So those are examples of kind of things that residents can still identify taking place within the house that they may turn in. And so that also includes that 8% there. But 92% of the time when someone calls to file a concern, it's about an exterior violation. Last slide I wanted to show you before we talk about potential enhancements is, and I think another important one when it comes to activity. So one of the things we have is the rental registration program, but of course we have our regular code enforcement, we have a health department, we have a fire marshal's office. There are a lot of different departments that help us make sure that our individual dwelling units and our multifamily complexes and our neighborhoods are safe and kept in good order. So what I did here for you is looked at all of the rental properties, so the 2,700 rental properties. If you look at the code enforcement activity at those properties from January 2012 through present, what you find is that we've sent about 10,000 notices to those 2,700 rental properties. Now, many of those have received multiple notices. Some have not received any. But on average, you can see on average there, from the 2,700, there's about 4 notices per property on average over about a 19-month period there. Again, if you look at what those notices, the types of violations that we're seeing there, almost 88% of those are going to be exterior violations. And again, about 12% or 1,350 of those are going to be interior violations. The vast majority of those done through the rental registration program. The others are a combination of issues found by a variety of different departments based on a variety of different kind of concerns expressed to the city. So considering the 4 slides I've just shared with you that generally say, even when you're just looking at the rental registration program, the focus is generally more on the exterior. When you look at complaints, the focus is on the exterior. When you look at activity overall, the focus is on exterior violations. We've got a couple of considerations for you. We'll call them 2 considerations. Consideration 1 would be to refine some of our existing language in the current ordinance so that we do the 2 things that I mentioned first. 1 is we make that language more consistent with what's being used in other programs, and 2, that we make it easier for residents to understand, property owners to understand, and then therefore to comply with. So it's no substantive change in the actual regulations. It's more about improving the ordinance itself and the way that it's written. So therefore, registration would still be required within 30 days of a tenant, the first tenant occupying the dwelling. Registration would be required to be renewed annually, and registration form would be required to be renewed annually in conjunction with that registration renewal. If you look at the inspection would still be required. An interior and exterior inspection would still be required within 30 days of the first tenant moving in and within 30 days of all subsequent changes. We would continue to utilize a score sheet to assess the condition of the property, require an 85 to pass, and require all properties that scored under an 85 to have a reinspection. Consideration number 2 is a little bit different. Instead of amending and clarifying the existing language, we would revise the existing language to modify some of the current requirements, and we would do that in a couple of ways. One, here we would require an exterior inspection annually. So right now, as you saw, there's about 650 or so on average over the last 19 months. If you extrapolate it out to 2 full years, you got about 650 properties a year on average are switching a tenant or starting to rent their property for the first time. So right now we're conducting about 650 exterior inspections a year. The goal here would be to focus on what appears to be the community interest and the community concern on the exterior, and would be to conduct an annual inspection every year. The owner, sorry, I'm one slide behind. The owner and the tenant would both be notified in writing of the date and a time, a window, essentially, that the exterior inspection would be conducted. And at that time, we would also take an opportunity to notify the owner that an interior inspection is available if they want to choose that. As I mentioned, you noticed a lot of those interior a lot of the interior violations were generated from tenants requesting an inspection, similar to what we have in our apartment inspection program, where we go out and we offer an interior inspection in conjunction with an exterior. We would do that here both in writing, and then when we arrived at the property to conduct the exterior inspection, which would be required, we could again reinforce and offer the interior inspection to take place if the tenant desired to do that. If the owner and or the tenant, either, we would encourage them to be there for the exterior inspection, but that wouldn't necessarily be required. And if it's certainly go and, as through the inspection administrative warrant process that we described, we could certainly go to a magistrate and suggest why we think that it's warrants have an administrative search warrant issued for us to conduct that inspection. So if a tenant refused even on the exterior inspection, we would have that ability to obtain that warrant to conduct the inspection if we deemed that to be what we needed to do. We would conduct an interior inspection under a number of conditions, a number of different situations. One is when a tenant would request that inspection in conjunction with their exterior inspection. So whether they, in response to our letter or response to our offer, when we're there on the property that day conducting the exterior inspection, we could conduct an interior inspection in conjunction. It could be based on our observation made during that exterior inspection. We could request of the tenant, based on something that we see from the outside, that we be allowed to do an interior inspection, and then the tenant could consent to that. If the tenant did not consent to that, again, we have the ability to go to the court and to request a warrant based on what we observed during the exterior inspection. And again, you can see here down at the bottom, this strategy is essentially, and for the most part, what we're doing in the apartment complex. The apartment complexes, with a small difference only in that when we're dealing with those, we're dealing with 3, 4, sometimes as many as 800 units. So we approach that a little bit differently. It's not as personal a touch as you might find us as having here, with forwarding the letter first and then being able to truly visit with each individual tenant if they opted to do that during the exterior inspection. So an exterior inspection would also be conducted, both an exterior and or an interior inspection could also be conducted at any other time. So it's not just at the time of the annual inspection for the exterior and that interior inspection that may take place at that time. It could be at any other time if a owner requests that we do the inspection if the home is vacant, if a tenant requests that we do the inspection if the home is occupied, or again, if the city has other probable cause. So it could be at a completely different time, but something's come to our attention. We could ask the owner or the tenant, as appropriate, if they consent to the inspection, and if we feel strongly that the inspection needs to be conducted and they do not consent to the inspection, again, we could obtain a search warrant, administrative search warrant from the court if the judge deemed that was appropriate, and we could conduct the inspection via that search warrant. So you might ask, well, what benefit above and beyond what we normally do through code enforcement might this exterior inspection on an annual basis net for the city and for the neighborhood and for the community? So there are a couple of ways to look at this. One is, if you look at what we see now in code enforcement, everything we see has to be from a public right-of-way. And it has to, essentially, it's from the street or from the alley. And sometimes there may be an easement that we could utilize to make an inspection, but generally it's from the street or the alley. And the kind of things that you normally see is if it's obvious, the condition of the paint, the wood of siding, doors and windows if they were broken, for instance, shutter screen if they were tearing down, condition of roofs and soffits, walls, chimneys, foundations, stairs, handrails, and guardrails that may be exterior. And, of course, fences, screening walls, and retaining walls. This last one's important because while we can many times assess the condition of those, they prohibit us from assessing the condition of a whole lot of other things that are important on the outside of a house. And what I've done here is kind of shared with you some of the things that are not easily viewed from our traditional code enforcement standpoint that might be beneficial to be able to get on the property and see on a regular basis. Right now, for instance, with the serious condition that we have with West Nile virus, the condition of pools and pool equipment to a certain extent is a very high interest to the community in making sure that those are treated in a timely way and that they're not allowed to generate and increase the likelihood of mosquito breeding. To that end, improper drainage, standing and collected water that may not be visible from the exterior, the drainage in particular in side yards, which is so close to the neighbor, has a direct impact. The existence of illegal accessory structures in addition. We recently obtained an administrative inspection warrant to take a case before the Building and Standards Commission, and when we got behind the 8-foot wood-on-wood fence, we found 4 illegal structures that had been constructed within the last few years. And the fire marshal felt so strongly about that, he came down and testified on our behalf that because none of them met the setbacks or had any of the related construction integrity that which you expect, that he suggested we tear them down within 30 days. This is the kind of thing that you would be able to only see, particularly in a backyard, if you were able to do an annual inspection. Again, a condition of accessory buildings, unobstructed means of egress and ingress. Obviously, one of the main things that we want to make sure that when someone is renting a home is that they can get out of the home if that need to be the case. And one of the things that we find in that 900 or so of the life safety violations that I mentioned are windows that, for a variety of reasons, are no longer operable. It could be windows that have painted many, many times and won't open. It could be windows that were nailed shut for some reason. It could be windows that had unique locks that you have to have special knowledge of to open, which are not permitted. So these are all things that we would be able to see walking maybe past a window that we would not be able to see from a street or an alley. Rodent insect infestation, obviously, one of the ways of knowing that, particularly in the day, is to be able to see the things that they leave behind. You wouldn't be able to see that. And then junked or other prohibited vehicles that you might see behind a fence. Particularly, one of our biggest issues right now that we're working with the health department on is to reduce the amount of storage, automobile storage, parts and accessories and things of that nature, tires that hold all this water that result in the mosquito breeding. So all of those are things that we would be able to do a much better job on if we were conducting an annual inspection. Then you can see also hazardous chemicals and things of that nature. So as we looked at these two options, we also wanted to give some consideration to the fee. As I mentioned, it was raised in 2011 to help offset the costs associated with implementing the enhancements to the program. What I've done for you here is given you kind of a January 12th through July 13th level of activity, and that's 19 months. And then kind of given you what we estimate under the two options or the two considerations that we've provided you tonight, what that activity might look like. So you can see, I mean, we've actually, in the last year and a half, we've on average, each of the last 2 years, we've come up about 200 rental units. So when we adopted the enhancements in December 2011, it was about 2,500 rental units. That number now hovers around 2,700. So regardless of what option we do, we're going to continue to have to do the invoicing of the annual registration and the fees associated with that. Just because we change the program and leave it the same tenants are going to still turn, so whether we're doing, we're going to have to process the updating of the registration form so that it reflects the information accurately for the tenant. There's always going to be a certain amount of education and enforcement, but education predominantly when it comes to new property owners who utilize their dwellings as rental property. So we're always going to have a situation where we have to have some effort put towards getting folks to register, renew, and to pay their renewal fee. So you can kind of see, based on the history, that's about 1,000 notices a year we send. And then some of those, luckily, just about 12 or 13% result in court action to gain compliance ultimately. So you've kind of got voluntary compliance here and then a little bit more of a forced compliance down at the bottom there. And then finally, the exterior inspections is the main difference between the refinement strategy or consideration and the second consideration, which would require the annual exterior. Obviously, there's significantly more inspections would be required. But then when you think about the interior as well, interior inspections, you would say would be the same because you'd have that change of occupancy, about 650 annually. But we really don't know for certain here how much that would look like. How many people would look at our willingness and offer to provide an interior inspection free of charge to make sure that their situation, their family is safe? How many people would take advantage of that? If it holds true to what we find in multifamily apartment complexes, that number on an interior under that is going to be anywhere from about 400 to maybe about 550. About 20% of the time, somebody's going to take advantage of that. My personal opinion is in single-family rentals where the tenure of the occupant tends to be much longer than in the multifamily, that number could be closer to 1,000, where we have much higher level on an annual basis of folks. And not everybody will do it. Not everybody will do it every year, but you just don't know fully yet what that number could be. Based on that, as I mentioned, the fee being raised, based on and given the fact that under option consideration 1, the activity would not likely change very much other than we continue to register more and more properties as we've demonstrated over the last 2 years, 200 or so more than we started with. And that under consideration 2, we would probably be looking at significantly more inspection activity, particularly as related to the exterior inspection. Given both of those facts, we do not recommend a fee change at this time and feel like the $75 that you adopt in November 2011 is still appropriate for the program under either of those options. And Mayor, I do thank you for your patience as we work through that, and I think we've got a couple of just next steps here. Obviously, we would happy to take any questions and offer any additional insight that I could. We would either suggest refining or amending the current ordinance and then bringing, whichever way the council directs us to, bringing that back to you at a future date for your consideration on a future agenda.
Great job of presenting that. Thank you very much. So I will now open it up for questions, comments, discussion from anybody. Yes, Mr. Dunn.
Thank you, Don. Very good presentation. One of the things I want to say is, I think I've mentioned it many times, I meet with presidents of homeowners in place 3, tried to do it quarterly, and our last one, this topic did come up, and it was overwhelmingly appreciated that what the city has been doing with the rental registration. As you said, their main goal is to keep their property values up and the neighborhood integrity and everything else. So the homeowners in place 3 really like the rental registration. So good job on enforcing it and moving it forward. Thank you.
Okay. Yes, Mr. Townsend.
Yes, Don. Whenever we've talked about this before, I've always been on complete interior inspections. But now that I'm leaning toward option 2 up there, I think we're going to accomplish the same thing. The only thing I would like to see changed, I would like to, where you say notice will offer interior inspection, I would like that to say the notice will encourage interior inspection, so that we can, rather than just having them say yeah, but we can actually encourage them. But I'll be happy to support this option 2 this time.
Great. Thank you.
Mr. Mitchell.
Thank you, Mayor. Dawn, I think this was a very good presentation, and I think it was very timely because, we've always made a commitment to evaluate these types of ordinances that we put in place in our city on a regular basis, and so I think this comes at a very good time. And I think with that, I think that option 2 actually brings up some very, I think, interesting aspects of what we're trying to accomplish when it comes to health and safety in our community. I think that the ordinance that we have in place, I think, has served us well in many ways. But what I'm finding, based on what you have presented tonight, is that really the issues involve exterior. And what it is that overwhelmingly, I looked at this, 88% of the violations were exterior violations. 92% of the complaints were exterior complaints. Now, people can't see really what's going on inside, but on the whole, those are incredible numbers. And so when I look at trying to utilize the resources that we have, which are limited in a city of 100,000 people with a number of rental properties that are here, to me, I look at option 2 as a very viable way of accomplishing what we want to see as far as health and safety goes. A focus on an annual inspection of the exterior, to me, makes a lot of sense because what we're doing is we're actually going out to the properties on an annual basis and focusing on the things where we're seeing the predominance of the violations. And I think that's what we're mostly concerned about. That's what we are concerned about. That's what brings property values down when you have homes that, at least on the exterior, do not meet the standards that we feel like they need to meet for health and safety reasons. So, to me, what I think is when we look at these options, I believe that option 2 is a true enhancement of what we want to see in our city, which is compliance and health and safety. And again, when you look at the issues that are reported and the issues that are actually cited, it's exterior issues. And I think that the comment that Bob made about, encouraged, if people want to have the interiors of their homes inspected, that's fine. But what we're going to be doing is we're going to be focusing on what seems to be the biggest issues, which are exterior. And to me, that makes good sense. I think it's a good use of resources, and I'd support you going with option 2.
Mr. Velker.
Thanks for the information on this and a couple of clear options. Maybe a comment and a question. I agree with Bob and Steve's comments on the encouragement. I think from an educational standpoint, especially for the tenants, when you were there, a flyer or a brochure would be very helpful so they could see that checklist of things, outlets, water heaters, the types of things that could be wrong in a home that often, I've rented and owned and, I've had home inspections done and I miss things constantly. So having that little cheat sheet of things that we're going to look for their safety, I think would be beneficial. On the exterior side, on the kind of a definition of easement and access to the easement, I'm curious as to, especially some of these easements are in backyards that may be fenced, gated, locked. What are our rights to access that easement?
Sure. A utility easement that is on private property, we would still request the permission of the tenant, and then if we did not obtain that permission, we wouldn't try to use that type of an easement to conduct an inspection. I was referring maybe more of a common area easement, for instance, maybe in a mandatory association where there happened to be a common area or some other type of utility easement that was on a common piece of property versus a piece of private property, but we could go into that common property, into that easement, and that be still considered a public right-of-way type of a situation. But if it was any type of an easement, but within private property, we would request the permission of the tenant under this scenario, and if we didn't get that, evaluate whether we wanted to seek and try to obtain a warrant.
On a classic home that has an alley and a sidewalk out front, the city has the easement to the sidewalk. so you
Absolutely.
can stand on the sidewalk.
Absolutely.
And in the alley, they have the easement probably to the fence line.
The vast majority of time.
All right, Mr. Solomon.
Don, thank you again. This is very good. It's very interesting to see the numbers. You know, we can actually see it. And I think it's like Mr. Mitchell said, it's good to review these things after we've had them on the books for a while to see. And I think that the enhancements offered in number 2 really address what we want to do with the annual inspections. I really thought we were doing that sort of what we wanted to do in the original motion, but we just didn't get there. So I think this is a great enhancement, and I'd be glad to support that with Mayor Townsend's corrections.
All right, and Mr. Hartley.
I too enjoy or are in favor of what the other council people have said. I do like it. Just to note another thing, it kind of puts the multifamily and the commercial and the residential on the same playing field.
Any other comments, questions? Yes, Mr. Mitchell.
You know, Don, one thing that I think that is important that I would want to hear from you and your team is that, you know, Richardson has been, in many ways, I think we've been very successful in implementing a lot of programs, ordinances, whatever term you want to use, in addressing revitalization and keeping our standards up. And I guess what I want to hear from you, and you know, based on what I've seen, again, I think option 2 is the enhancement is the best option. But what I'd want to hear from you is to make sure that in your opinion that this continues to keep the high standards that we've set, because you know, Scott is correct. You know, there are many people in this community that support an option 1 out there. But what I think it's important for the city and for you to be able to say that, you know, we are going to accomplish and continue to accomplish keeping these standards high by going with the enhancement number 2. So can you?
Sure. I do think for a combination of reasons that this can prove to be a very effective strategy that does not reduce the impactfulness of our code enforcement program. I personally believe that you know, a lot of tenants will view the opportunity to have a free inspection done on the interior of the home as a valuable service. I've met over the course of, you know, numerous years a lot of folks. It could be the single mom who just wants to make sure that the water heater is installed properly, or that the gas furnace is installed properly. That a week after moving in and it drops to 30, to to that same a mom and a dad who wants to make sure that the smoke detectors are operable because maybe their kids are home for a little bit in the afternoon by themselves. So I think that we are still going to achieve a high level of interior inspections via tenants looking at this as a valuable service, as we've done for many, many years in multifamily. And then I think the strategy of being on a property and being able to do an exterior inspection. I mean, another lesson learned over the years is that, you know, folks don't necessarily do a real good job on the outside if they aren't doing a good job on the inside of maintenance. So you tend to see, when you tend to see exterior issues, there probably are going to be interior issues, and as we've tried to kind of provide some examples of the types of things that could justify and be seen as a magistrate as probable cause, what you do on the outside is an indication of what you do on the inside. So if we, through our exterior inspections, whether it be through direct observation or you know, passing a window and seeing 3 beds or 4 beds in a garage by looking through the garage window. I mean, those are the kind of things that are going to allow us to still be effectively, I think, deal with situations that for years and years and years we've been trying to make sure don't impact our community like it's impacted others. So I still have a high level of confidence that this strategy can allow us to remain effective in the code enforcement realm, and particularly because we do so many other things to complement this one program.
Well, and let me add to that is I think that when I look at this, it truly is an enhancement, again, because we've got the annual exterior inspection. But what's good about it is that we also have reserved the right, so to speak, that if there's probable cause for an interior inspection, we still have reserved that right. So at the end of the day, what it does is I think it gives you and your team the flexibility that you need to be able to implement, I think, the goals of what we've said, which is, a high standard for rental properties. Would you agree?
Yes, sir.
Okay, thank you.
Yes, Mr. Dunn.
Before we get off this topic, I wanted to make sure I did not encourage option one. I just said that the homeowners,
I'm going to
the
summarize it. It's
residents
okay.
were wanting strong code enforcement on rental registration. That's what my statement was. I'm in favor of option two. I just don't want it to be thrown under there saying option one. So.
Right, well, I'm going to make sure that we're real clear on what everybody's direction is before we move off of this one. Yes, Mr. Velker.
Don, this may be, we might want to go to Peter Summit for legal advice on this question. I want it similar to the way a brochure for the tenant might be available, so that that's a good thing to look at. I want to be clear to the landlords that if we don't do an interior inspection, they know what we would have looked at. And through the registration form, those things are clearly pointed out. And if that window's painted shut, if that smoke detector doesn't work, they know that it's on their shoulders that this is happening.
Yes, sir. We can absolutely have a resource that we attach and provide with the application. But and to get to your legal question and how that legally plays out, ultimately it is their responsibility. And whether we do an inspection or not, in the end, if something happens at that property, it is going to be the responsibility of the landlord to whether rectify it and make it right, or to have to deal with the consequences associated with that. But I think that the education, we rarely come here and talk to you about enforcement without saying education, and I think that an opportunity to provide a very specialized resource that we can provide every time we provide a registration form to the owner, and then provide a similar but unique resource for a tenant, whether it's when we send them the letter telling them when we're going to do the exterior, or when we knock on the door and tell them that we're there to do the exterior, or when we're responding to their request for help for some other reason. I think all of those opportunities are something that we can seize on, even more so than we already do.
Right, any other comments? I'm going to weigh in here too, just since this has been such a topic. And, I think at the end of the day, our goals for any sort of code enforcement are, and they were in the presentation, vitality, integrity for the city, health, and safety. And I guess from my perspective, those goals apply not only to rental properties, but to all properties. And so by making this ordinance a little more consistent with how we treat other properties, I think that, this question about treating rental properties differently really isn't, because we do have these same ordinance and the same goals for our regular properties. And I think that it's important to also note that a warrant for any property can be sought. So believe me, as you were going through that list, I was thinking, I wonder if all my fire things work in my house. And so that kind of brings me to my next point, which is somewhat along with what Mr. Velker said, which is, I think that this has got to be something that we as a city educate not just the rental properties, but also the homeowners, the senior citizens who may not realize that the fire department will come out and check those fire alarms and things like that. And so I think that, again, I think part of our job as a council and as a community is to educate people how to make their places where they live as safe and proper as they can. I agree with what everybody is saying. The exterior issues are definitely what we hear the most about. We definitely hear about it from the homeowners leadership. And I think it's when they see those exterior downgrades, for lack of a better word, that's when this whole issue of rental registration tends to pop up. So I, too, am in favor of option 2. And I think that that's a consistent, that's what all 7 are. So I would say that our charge to you is to come back to us at the appropriate time so that we can amend this ordinance on a council agenda. And I think that's what you need from us this evening, correct?
This is great feedback, exactly that. I do want to acknowledge Don's work on tracking it, certainly listening to a variety of inputs. Don, I think, very responsive on bringing forward a series of suggestions. Appreciate this response tonight. We'll be fast in bringing that back to get effective with that. And much as we talked about ordinance refinements, I think the other point many of you brought up was the idea of outreach and programmatic and communication techniques. And I know that Don has been active with Greg and others on behalf of mediums and different formats for that. And certainly we have various forums that we will also be trying to update and make those refinements as well. So this has some programmatic response beyond merely just an ordinance refinement, but that is certainly a fundamental piece of that, and we'll be quick in that work and then go on with the other outreaches as well. There's been some work in the last little while too, and I think we're going to go back and reflect and see, going forward, what's the best approaches now with this new, with this updated direction here on kind of reviewing things that have been active this year, and we'll take a look at that as well.
Well, and I guess my final statement would be that, I personally will be interested in having a year from now, if we adopt this ordinance, let's just go ahead and say that 1 year from right now, again, we're going to look at it, and my opening statement I'll stand firmly with, which is you don't know how the outcome of an ordinance is going to work until you actually implement it for a while. And I think that, our intents are positive, and we just want to make sure that that's what's actually carried on a year from now once we have some more data.
Absolutely. Thank you.
All right, and now moving on to the next item on the agenda.